Hi, I'm Dr. Anthony Edwards, and I'm the instructor for Higher Education Politics and Policy. Today, we're going to be talking about the relationship between students and their institution of higher education. So, a quick disclaimer: the information that's going to be presented here is provided for educational purposes only and should not be considered legal advice. All right, so let's talk first about the legal status of students. So, again, we talked about this a little bit before, but students are considered adults in college, and there was a change in the age of majority. So it was originally 21 and has now become 18, and so that has changed the view of students and how what their rights are as adults. uh, and we talked about in this course, we talked about contracts. So in terms of our well, in terms of the interaction between institutions of higher education and students, there are some elements of contract law, and so there are some rights that are associated with that. Also, there's the concept of fiduciary duty, and fiduciary is someone who is supposed to operate in someone's best interests. All right, and so here, things we have to consider if there is a fiduciary duty. Does the faculty or staff member or advisor have the student's trust and deference that they defer to the faculty member or the advisor? Does the advisor have contributions that help support the student's work? And does the advisor make contributions that help the student improve their research and their writing? And this tends to happen in the context of things like dissertations and master's level theses, things like that. We also talk a lot in the chapter about student academic freedom. And so some of the freedoms that we talk about in this chapter deal with freedom of expression, the freedom to learn, free exercise of religion, basically a freedom of association, things like that. There also is a term that is introduced here in the Lemon Test, and it comes from a case, and it deals with public colleges and religious issues. So, whether there is a establishment of religion or allowing free exercise of religion, because again, while you may have a public institution of higher education, they may have students who have particular religious views and have rights associated with that. And so Lemon Test deals with that. Also, in terms of the American Association of University Professors, they came up with an academic Bill of Rights. It's not a law. There are some states and some institutions that incorporate some principles from that, but it's a framework for which a lot of the rights of students come from. Okay, so liability is obviously an issue that we deal with in this course. So there's some liability in some cases for the student, in some cases for the institution. Particularly when we think about student liability, we think in terms of ways in which students actually might be harming other students. And that could be obviously in the context of an assault, things that unfortunately do happen to college students. And also, you think about maybe hazing, slander, things of defamation. We talk about that. Negligence. So is the student or the institution negligent? Were they aware that something bad could happen? Did they take steps to prevent it? Things like that. Would that be a reasonable thing to do? But again, we deal with defamation in terms of maybe faculty or other students or staff or other students saying things about a student that maybe defame their character, and what rights do those students have at that point. Obviously, as we said, we have issues of assault and harassment of students. And so there are going to be some issues we go through the course. We'll talk about how that's handled and what things institutions need to consider in dealing with these cases. All right, so in terms of admissions, there's a lot of talk, a lot of concern about admissions criteria and admissions decisions. And so there's some general principles that are important. So admissions decisions should not be arbitrary, and they should not be discriminatory. They shouldn't discriminate against any group, and they shouldn't just be making up rules or making up why they want to do things, but without any criteria. And these criteria need to be available, and they need to be followed. So if you have some criteria, they need to be used and not going off and doing some other arbitrary decision. There are some issues that come up with students in terms of falsifying application information. So if they don't tell the truth about maybe their academic history, that can be considered a breach of contract. And so admissions decisions could be revoked. There's also issues of equal protection in terms of how students are treated in the admissions process, and are they treated the same as any other student, whether that's based on their race or ethnicity, gender, any other criteria, accessibility status. All right, so again, contract theory can come into play, and particularly, we think about admissions decisions, those can be considered contracts between the student and the institution. And so it can get into situations with oral and implied contracts. So, maybe someone is told verbally that they're going to be admitted, or they've been admitted, or there's an implication that, an admissions decision might occur a certain way, and then if it doesn't, has there been a breach of contract? So making sure that admissions decisions are provided in writing is probably going to at least be something that's going to keep folks from making decisions that they might get problematic. All right, in terms of non-discrimination issues in applications, we've gone a long way from Brown versus Board of Education in the 1950s to the Fisher case in the early 2000s to Students for Fair Admissions in 2023. And so we've gone from essentially not allowing discrimination or segregation of students based on their race or ethnicity to there's a point at which there have been cases that allowed for things like affirmative action and admissions decisions, and moving to Fisher, you get to a place where there's sort of this feeling that there's a lot of time that has passed since Fisher, or passed since Brown. And so there's a sense that there might be a time for which those kinds of practices are no longer necessary. And then it was put out at maybe 25 years. But we get to Students for Fair Admissions, and we get to a place where the Supreme Court justices felt that time had come. And so there couldn't be any admissions criteria that could be perceived as discriminatory toward any group. Now, in terms of segregation, again, we particularly in Brown, but in other cases, you deal with things like de jure versus de facto, and jure, that root word deals with the law, so that would be segregation that is mandated by law, and then there would be de facto segregation, which basically means it's not written that way, but the impact is that way. So that it essentially created segregation, even if it wasn't written that way. And and so there are issues with not allowing for de facto segregation either. Again, there are issues of liberty interest and property interest. In terms of liberty, their freedom to attend college or the school that they feel that they're have the criteria to be able to be admitted to. Property interests in terms of that contract that exists and feeling that there's a property interest to attend that institution. So those are sometimes issues that come up with cases. There are some exemptions for religious institutions based on their background, but it has to be clearly stated that they are a religious institution and they need to be operating as a religious institution. It can't be when it's convenient. Obviously, admissions, there are going to be some issues with Title IX and gender, particularly when you look at single-sex colleges, and much of this is dealt with cases where a student who is not of the gender that the majority of the students are at that institution wants to attend that institution, and whether or not there is a Title IX issue at play there. Particularly when you look at accessibility issues, we will see things like Section 504, the Rehabilitation Act, or Americans with Disabilities Act come into play. A lot of this deals with what are reasonable accommodations and whether or not a student has to meet certain criteria from an accessibility standpoint to be admitted or readmitted, and that can create challenges for those students who may or may not meet those things, and also whether or not there is a accrediting agency that accredits the program, and are there standards that are associated with that the institution is obligated to comply with. All right, so again, some of those first four we've already touched on, but we also deal with issues of reasonable accommodations and would someone be otherwise qualified. So if they didn't have the accessibility issue, would they have been qualified? Also, in terms of these issues of non-discrimination, there has to be some sort of direct and substantial relationship, for that institution, in terms of, them, if they're going to say that this, if the student is going to say that this is discrimination, they have to be clear that this actually is causing, a harm to them by not being able to attend that institution. All right. Race neutral versus race conscious admissions. Again, moving from, race conscious admissions being kind of in the area of affirmative action, but there's been obviously a move in more recent years toward race neutral admissions policies for both public and private institutions, and this basically encouraged, mandated institutions look for race neutral alternatives to achieve some of the goals that were wanting to be achieved, but doing it without discriminating against people of certain backgrounds. So, for example, one of the things that changed in Texas, 1996, around that time when Hopwood decision came out and affected Texas, particularly public institutions, there was a move from away from using race in admissions to the top 10% policy, and that policy didn't really matter what your background was, but we know that there are certain public schools that have different demographics, and that was looked upon as a merit-based way to encourage students of different backgrounds to attend the institutions, but it was done in a way that technically doesn't have race as a factor. So, also issues of disparate treatment versus disparate impact. So, disparate treatment would mean that there is a clear difference in the way certain groups are treated compared to others. Disparate impact would mean that that even if the groups are treated the same on the surface, the impact on those groups is different. So if you implement some policy, certain groups may benefit more than others. So that's sort of the disparate impact. All right. Again, in terms of recommendations for admissions committees, making sure that you have criteria and use those same criteria for all groups. Again, we talked about issues of readmission, and so it kind of goes back to a lot of these other topics that we've discussed, and whether or not a person can or should be readmitted. All right, so let's go on to the issue of financial aid. And so again, we deal with contract issues, and particularly whether or not the student has met their obligations, and this is typically on the scholarship side of financial aid. So a lot of times scholarships have criteria. The student may, in some cases, not uphold the criteria to maintain that scholarship. They may lose it, and there are some cases where the student has sued over that or brought a case to trial. But a lot of the cases have centered on if their work clearly stated criteria and the student didn't meet them, that those were awarded in the favor of the institution. Also, the issue of athletic scholarships. Again, this is on the scholarship side, but typically athletic scholarships are renewed annually, and in the fine print, those scholarships are not automatically renewed, or they're not entitled to be renewed. And so students may attend an institution, and then if the institution decides they no longer want that student athlete, they have the right to terminate that student scholarship. And if the student can't afford to attend that institution without the scholarship, that student may have to leave and go somewhere else. All right. Again, scholarship criteria, and there's sometimes issues of whether or not the criteria has to be followed. There's some cases where scholarships criteria are maybe have things that were legal at one point that are no longer legal, and there are certain issues where institutions can't legally discriminate, right? And so those can sometimes become issues. Again, Family Educational Rights and Privacy Act, and so again, this deals with the students reaching the age of majority and who can get information about financial aid. Again, sometimes you have issues where the parents are paying, but the student is the one who gets the financial aid information, and it's up to them a lot of times to share that information with parents. There can be some situations where when a student is a dependent on tax returns, that there may be some level of information that parents receive, but again, typically these students are treated as adults. All right, so again, eligibility criteria, the institution can set their own criteria, and so there are sometimes issues where the institution has to make sure that the criteria that they've set are legally appropriate, but they do have the right to set some criteria for their scholarships. Okay, gainful employment. Okay, this is kind of getting into an issue of institutions' ability to continue to receive financial aid. This tends to come into play particularly with for-profit institutions if they are promising that students will get jobs in their field after graduation. Typically, there's a heightened level of scrutiny on those institutions, but gainful employment is something that really all institutions are having to look at or are being measured on. So arbitrariness is going to be a term that we use throughout the chapter. So again, these decisions for scholarships can't be arbitrary. There has to be some clearly identified procedures as to why certain people get certain scholarships. Higher Education Act, Title IV, deals with the criteria for receiving financial aid, so just want you to be aware of that. Incentives and enrollment, so particularly when it comes, and this is perhaps more on the admission side, but deals some with financial aid in the sense of, they can be an incentive for that student to enroll, but for the enrollment staff, there are very tight stipulations on the way the enrollment staff are paid, and so there typically is really guidance against offering any kind of incentives or bonuses based on how many students are enrolled and things like that, because it could encourage people to admit people that aren't going to be successful. State authorization of distance education. I used to work in distance education administration, and so this is a really important issue. Obviously, this is an online class, but it deals with authorization to offer online courses and programs across state lines, and there are programs that offer institutions that offer programs in areas where they're not authorized run the risk of losing financial aid. So that's one of the reasons why state authorization is so important. Okay, so other issues with financial aid, you have default rates. So if a graduate or someone who is no longer attending college, whether they graduated or not, can't pay back their loans, it can go into what's called default. And if the rate of students who go into default from an institution gets too high, that can compromise that institution's ability to get financial aid in the future. Also, it's related to gainful employment. Students, when they go to a school, there's an expectation they can get a job with their education, and so again, if their students are either not able to get a good job, and then therefore that doesn't allow them to pay back their loan and they go into default, those are issues that can compromise an institution's ability to get financial aid in the future. We see this a lot of times with for-profit institutions, but really all institutions are evaluated based on that metric or those metrics. There's a resource, the Information for Financial Assistance Professionals, that can be helpful for people who work in that space. Again, we don't want discrimination against groups in admissions, but also in awarding scholarships and financial aid. There are some issues in terms of what financial aid can be available to non-citizens. There are some cases where certain types of funds can't be used on non-citizens. Also, issues of whether or not the aid that we're talking about in a particular situation, whether it's state aid or federal aid, because there are different regulations that may apply depending on whether the aid that's involved is state aid or federal aid. All right, so some of the issues that we dealt with here in the student housing section deal with housing requirements. One of the ones that comes up a lot is requirement of students to stay in residence halls, and whether or not those are whether they're based on age, also whether or not someone can't, there's some issues with violating their own religious beliefs. So those will be issues that come up in the chapter. Also, could be a resulting duty for the institution in terms of providing housing, in terms of making sure that housing is safe. And we'll talk a little bit more about that later. Again, eligibility. Some students may be eligible, some students may not be eligible, and those who are not eligible may wonder why. And there has to be some explanation of why, and can't be arbitrary, can't be vague, can't be overbroad language. So important issues here. Equal protection, again, making sure that everybody has equal rights to stay in student housing if they are qualified. Freedom of association, so if a student does not want to associate with certain kinds of folks based on their religious beliefs, that can become an issue in the residence halls. Again, non-discrimination is a theme that goes throughout the book. And again, free exercise of religion. So if someone has religious beliefs that conflict with the housing policy, that can become an issue for institutions. Okay. Also, there can be some exemptions for private institutions because of their own, particularly religious beliefs. The Fair Housing Act, so even though it's not specifically about residence halls, there are some implications or some stipulations within the Fair Housing Act that deal with residence halls, and so institutions have to be mindful of that. Accessibility issues in terms of our rooms, accessible for students with physical or other limitations, and also funding in terms of costs. Is the cost for those students different than from other students? Also, we see this a lot in dealing with student housing, issues of service animals or assistance animals. Depending on the law that's being used, you may see the term service animal or assistance animal, but there are some protections for students who have animals that meet that criteria, as long as they do. Also, some issues in student housing dealing with searches and seizures and the Fourth Amendment, particularly whether or not the institution's got a warrant to do these searches and seizures. And so typically, if they are particularly for criminal issues, there needs to be a warrant in order to do a search of a residence hall or room in a residence hall or hallway or any other space. However, institutions can, if they have a policy that is clear and available to students, that there are health and safety checks that can be done periodically. Again, these are intended not as criminal issues, but just to check on health and safety of students. But when issues come up that may, trigger other maybe criminal concerns or other concerns, making sure that warrants are in place before those additional maybe campus, police or law enforcement get involved, or else the evidence that is obtained may not be admissible in court. Again, state action, if you're dealing with a private institution, in terms of particularly if they're getting local, state, federal law enforcement involved in a search and seizure, could potentially trigger a state action claim. So things to be aware of. Also, again, there are some exemptions for private institutions, but that's not a carte blanche exemption. It's not always guaranteed that institutions would be exempt. Okay, in terms of campus computer networks, we deal with obviously a lot of computer issues with college campuses. So freedom of expression is something that comes up. So if a student says things that others object to, what does the student have freedom of expression? All right, and again, are we dealing with something that is obscene, language, or is it a true threat to others and their safety? So those are some criteria as to whether or not that student may have freedom of expression. There are also some issues that come up in terms of communication that happens off campus. So obviously there can be communication using the, whether it's maybe student email system or learning management system, but those are kind of considered campus communication. But there can also be communication between students on social media, or texting, things like that, and what level of responsibility does the institution have for that communication that doesn't occur on campus? All right. The institution typically is going to have some level of responsibility for its own hardware, software, or forums, so even whether they're owning or leasing. So again, there's some issues as to what level of responsibility they have, but again, if the resources are not institutional resources, are going to be a lower level of responsibility. Again, regulations, rules in place in terms of codes of conduct. Things need to not be vague, and they need to not be overbroad in terms of interpretation of those policies. Again, we talk about true threats. Also, could some things be considered fighting words? And so those are also things that could be problematic in terms of student level liability. All right, so, and then there's issue again. We talked about the forums, and so there can be discussion as to whether or not the forum is a public forum or a limited forum. And so the institution obviously is going to have a higher level of responsibility for a public forum that they are essentially creating, or owning, managing, etc. When there's a limited forum, when people can only talk about certain topics, and it's clear that this particular medium is a limited forum, again, it can be a lower level of liability for the institution. Right to privacy. So again, there's a lot of student data that is created, stored in campus computer networks, and there's important to make sure that people who don't need to have access don't have access, and then issues when individuals share information that is protected or personal information. Again, can be issues of searches and seizures. So if people have computers, phones, etc., and they're maybe accessing that network, what level of ability does the institution have to search these devices? Again, there's the issue of whether or not a warrant has been provided. So all things to keep in mind. Also issues of computer hacking of these networks, and so what are the legal ramifications in terms of the institution's liability, and potentially its impact on the students. And also sometimes you can have situations where students may try to access a network in a way that's not appropriate, and how, again, going back to your policy, how does the institution deal with that? Some other information, particularly laws that are related to campus computer networks that you should at least just be aware of. Things like the Electronic Communications Privacy Act, the Family Rights, Educational Rights and Privacy Act, Computer Fraud and Abuse Act, Privacy Protection Act, the Communications Decency Act, the Digital Millennium Copyright Act, and there are also just going to be issues sometimes if students are utilizing data in ways that they shouldn't, could create student liability, particularly if they're sharing information that is not theirs to disclose. All right, in terms of campus security, there are going to be issues in terms of who is involved in these security incidents. Are they campus security officers, or are they local, state, or federal police? So that obviously there's going to be a different level of scrutiny for folks that are employees of the institution versus not, and and who needs to be involved in what types of scenarios. There's also going to be issues whether or not the issues or issues as to whether or not the situation occurred on campus or off campus, and what is considered on campus. In terms of language, there's some language that says that even property that is near the campus can be considered on campus. So it could be a reasonable expectation that the campus is aware of areas that may not be safe for students that are adjoining the campus. There are obviously issues of security when it comes to things like student protests, and how do you balance the need for safety of the institution with freedom of assembly and freedom of expression. Obviously, we've had in the last year we've had several incidents of that across the U.S. And institutions that have tried to figure out how to maintain that balance. And in some cases, we've seen some college presidents essentially, have to resign over their handling of the situation. But they are obviously challenges that campus leaders have to face. So there is a duty, depending on the situation, to protect students from violence. So there's and that could be, again, violence that could occur in a protest, but it could also be just violence that may occur in a residence hall. Could be violence that in any number of scenarios. But if there are things, depending on what is a reasonable expectation of safety, the institution could be liable. If there are situations where it's not considered a reasonable expectation, the institution may not be liable for that. Obviously, there's some issues of campus security with hazing of students by other students. Sometimes there's also alcohol abuse involved in some of these, and there can be issues particularly with fraternity and sorority houses, and whether or not they are considered residence halls or whether or not they are considered private housing, and that can the level of accountability the institutions have over fraternity and sorority houses can be equal to that of residence halls in certain scenarios. And so we've seen some institutions that allow fraternity and sorority houses to operate and some that do not, or allow Greek letter organizations and some that do not, and typically that has to do with some of the institutional liability issues. All right. There are also issues, again, of negligence on the part of students as well as on the part of the institution. It could be, again, with hazing. If there are students that allow hazing to take place, students could be held liable, or if they haze other students, could be held liable. Premises liability, again, things happen on the premises, the institution could be held liable. Other or laws related to campus security deal with the Campus Security Act, also known as the Clery Act, Higher Education Opportunity Act, and Campus Sex Crimes Prevention Act. Again, a lot of these deal with reporting and what is required reporting of safety issues that happen on college campuses. All right, so some other support services to be aware of, again, students with disabilities, and so there can be issues of vocational rehabilitation and who pays for that. So there are vocational rehabilitation agencies, and they do sometimes bear some responsibility to pay for students who want to get education in higher education. Also, international students, there can be some issues there in terms of visa categories and requirements to attain those visas and to maintain those visas. And also, can they work? Can their spouse work? And also, who can come? Can spouses come? Can children come? but different types of visas for different kinds of scenarios. But that can also impact students in terms of, or their ability to be on campus, and also the institution's ability to you know enroll them. I mean, there have been some changes in the ability to obtain those visas or to maintain those visas, and so that has impacted international student enrollment at many institutions of higher education. In terms of student records, the issue here is, what is an education record? And I mean, obviously, grades are an education record, but there are some other types of information and data that could be considered an education record. Also, again, privacy issues. There's that FERPA there, Family Educational Rights and Privacy Act. It can be an issue as to who has access to those records. So the student, in terms of their rights, they have the right to inspect their own educational record. They have the right to request edits if there are errors in the record. And they have the right to restrict access to that record within some limits. There are some cases where the institution doesn't have to have permission in order to share portions of the record, but there is some ability for the student to request or to restrict some access to it. Again, we get into issues in terms of disclosures and whether or not these disclosures were legal and appropriate. Again, there can be some issues in terms of the USA Patriot Act, particularly in terms of educational records for anyone that may be considered to have anything to do with acts of terrorism. And again, but the government would need to provide some evidence of that. We can't just accuse anyone of that, but there has to be some evidence in order to essentially have permission in order to access those education records. All right, so that is an overview of the chapter about students. And so obviously, in terms of assignments, you have a class discussion on the student-institution relationship. You've got this week the course feedback assignment, and then you have a post-course statement of understanding. Then you have the final exam. And again, that final exam, you'll have 2 questions, and they're essay scenario-based questions. And try to do the whole thing at one sitting. And directions will tell you in terms of citing and referencing in APA format. 5 or 6 sources is a good recommendation. Obviously, the more you do, the better. But really, 5 to 6 is kind of a meet expectations. All right, and it's been a pleasure learning with you in the course this semester. And if you've liked this video, please like the video and subscribe, and also share it with folks who you think might find it helpful. Thank you so much. Bye.